Sorry.
My Lord, just to pick up on one point before we were dealing with before the break, I was not saying that the test here that should be applied was, can you imagine the taxpayer making these exact payments without the intervention of the regulator? But can you imagine a trader making payments like these, for example, a payment to a charity, for the purposes of its trade without the intervention of a regulator?
Right. Okay.
So, my Lord, to put McKnight into context, could I refer you first to the case of Fender, which is in the authorities bundle at tab 4. Somewhat old-fashioned case where a man had promised to marry a woman on a divorce happening, and the claim was made that the contract was void for breach of public policy. And Lord Atkin makes some comments on the limitations on the doctrine of public policy, beginning at page 80 of the bundle. And basically what he's saying is, you can't make public policy up on the hoof. I make that point because, with the greatest respect, it seems to us that Lord Hoffman was making up public policy on the hoof. The next case is the Rangers case, called RFC 2012, in tab 10 of the authorities bundle. And the relevant passage here is at page 212. Starting at paragraph 11. Emphasizing that in tax cases, you are always interpreting the words of the statute. And I'm conscious that I haven't yet shown you the words of the statute, so perhaps I should do that. It's tab 2 of the authorities bundle, page 27. Section 35, the charge to corporation tax on income applies to the profits of a trade. Then section 46, the profits of a trade must be calculated in accordance with generally accepted accounting practice, subject to any adjustment required or authorised by law in calculating profits for corporation tax purposes. Don't think I need any more of that. And then section 54, in calculating the profits of a trade, no deduction is allowed for an expense not incurred wholly and exclusively for the purposes of the trade, or losses not connected with or arising out of the trade. If an expense is incurred for more than one purpose, this section does not prohibit a deduction for any identifiable part or an identifiable proportion of the expense which is incurred wholly and exclusively for the purposes of the trade. So the question in this case is whether the redress payments were wholly and exclusively for the purposes of the trade. I don't understand an attack on any other basis being made. So the question the court has to decide is whether, on my findings of fact, there is a rule of law that says payments in lieu of penalties are non-deductible.
I thought it was also being suggested that this was maybe an adjustment required by law.
Yeah, but I think it's 54.2 that requires the adjustment. It's 54.1 requires the adjustment because the payment is not wholly and exclusively. It may be there's another basis put forward, but that's...
We'll doubtless find out.
Indeed. I think it's probably going to come to the same thing anyway. So, my submission, the only possible place for a rule that a payment in lieu of a penalty or a fine is non-deductible is McKnight. In Von Glen and in Warnes, the payment was of a fine. Agreed fines in Warnes and Von Glen, but nonetheless a fine. So that takes us to McKnight at tab 8. And if I can start with the head note, it just says that the expenses are deductible and not prohibited by consideration of policy. So the head note doesn't record the decision as a decision that penalties and fines are non-deductible, but as a decision that legal expenses are deductible. Then we see at page 179 of the bundle, this is where we start to deal with the question of legal expenses. Mr. Grabner's second, I'm at letter H, Mr. Grabner's second point was that the words "for the purpose of the trade" meant that the expenditure must be in furtherance of the relevant commercial activity. There must be a sufficient connection with the earning of profits in the trade. This was not a case like Morgan, Tate and Lyle, in which the taxpayer was defending his business against an external threat. This expenditure resulted from the taxpayer's own misconduct, that is to say, from behaviour outside the proper scope of the trade. Mr. Grabner referred to Von Glen, in which the Court of Appeal disallowed the deduction of a penalty imposed upon a company during the First World War under the War Powers Act for exporting goods without taking all reasonable care to secure that the ultimate destination should not be enemy territory. Lord Sterndale said that although the incurring of the penalty was connected with the trade, in the sense that it would not have happened unless the trade had been carried on, it was not for the purpose of the trade, but because of a wrongful act on the part of the company. So that is the submission that was being put to the House of Lords, and there is no submission about policy there. Mr. Goldberg, I can assure you, remained very quiet on the question of policy and the penalties. So Lord Hoffman then criticises those decisions as curiously inarticulate. Now, we can miss out. My submission is that if you miss out from the paragraph beginning just above C to page 1, on page 180, and go to page 181 at letter E, you can start reading this decision at letter E, and you get the whole of the decision.
Well, except if you just kick off 181 at E, the first question you would alight on in the very first line is policy. Hang on, what's he talking about?
Yes.
Because if we followed you so far, you'd say, well, Mr. Grabiner didn't say anything about policy, and Mr. Goldberg didn't say anything about policy, so why is Lord Hoffman talking about policy? You do need to read the intermediate section, don't you?
Well, you don't really need to read the intermediate section because of policy doesn't add anything. The question is then whether there's any reason which prohibits the deduction of legal expenses. It works just as well.
Except the test he's applying at H is whether there's any clear reason the policy would be infringed by allowing the deduction, isn't it? You have to understand where that comes from.
Well, it's a general policy. Where does the reference to policy come from?
Well, it comes from 1337 at the very foot of the page, because what Lord Hoffman is saying is that the Court of Appeal were looking in the wrong place when they were looking at the question of whether the nature of the expense which prevented it from being deductible. He says the reason that it's not deductible is much more specific and relates to the particular character of a fine or penalty. And then its purpose, that is the character of a fine or penalty, is to punish the taxpayer. And the court may easily conclude that the legislative policy, I interpose, to punish the taxpayer, would be diluted if the taxpayer were allowed to share the burden with the rest of the community by a deduction for the purposes of tax. He's looking at the policy behind the legislation under which the penalty is imposed, isn't he?
Well, but where does he find that policy? If we go over the page...
The policy is that Parliament has said it's a criminal offence or a penalisable offence to do something. The taxpayer did it. It's not difficult to figure out that the legislative policy is that people who do such things should be penalised.
Where is
made to pay.
Where is the legislative? Over the page, he says, by parity of reasoning, I think the Special Commissioner and the judge were quite right in not allowing the fines to be deducted. Does not follow, however, that the costs were not deductible. Once it's appreciated that in a case like this, non-deductibility depends upon the nature of the expenditure and the specific policy of the rule under which it became payable. And which rule is that?
It's the statutory rule that provides for the imposition of the penalty, which makes it payable.
Well, if that is what he is saying, what is the statutory rule that impinges on the Taxes Act, which contain a rule that you compute in accordance with the ordinary principles of commercial accountancy. How does a rule, if there is one, in the Electricity Act qualify the provisions of the Taxes Act? That, with the greatest respect, is just making it up. There is absolutely no basis for saying that the Electricity Act is trumping the requirements of the Taxes Act. And that is particularly so in this case, where the penalty was not imposed, so the redress payments were not imposed by a legislative process at all.
We'll have to unpick that, because if we go back, he's talking, the analysis of von Glen, you'll see that at the top of page 1337 in the little bit you did show us, that in von Glen, the penalty was imposed on the company during the First World War under the Customs War Powers Act for exporting goods without taking reasonable care to secure that the ultimate destination shouldn't be enemy territory. So the reason for the nature of the expenditure and the specific policy of the rule under which it became payable in that case seems pretty obvious, isn't it? If there's a war on and Parliament passes a statute that says don't export, take all reasonable care not to export goods to the enemy, that if you're fined for that, the policy is to deter people from assisting the enemy in time of war. It's not a difficult thing to figure out.
But the policy of the Taxes Act is that you are to pay tax on your commercially computed profit, subject to adjustment.
But what Lord Hoffman is saying is it would be wrong to interpret that taxing statute as permitting the policy of in that case, the Customs War Powers Act, to be undermined by the defendant who has been fined or penalised being able to say, well, that's all right, because I can effectively share the burden of that fine with everybody else in the country by deducting it from tax.
Well, the War Powers Act is no doubt the sort of act where the sympathy of everybody would be engaged for a claim that you should not be able to deduct.
Well, we can imagine a number of homely examples. I mean, if you are driving your splendid motor on the way to court, wanting to be here at 10:30, and put the foot a little bit too hard on the accelerator and go through the speed camera, it would be a little difficult to say, wouldn't it, that the only reason you were making the journey to get to court at 10:30 was to conduct your trade or business, and you should be obviously allowed to set the fine off, the speeding fine off, against your profits.
Well, that may be, but the fine is not the same as the redress payments here.
Ah, well, that's a different point with respect. At the moment, we're just concentrating on what Lord Hoffman was saying about penalty. Sorry, Freudian slip. I'm sure neither of them would appreciate that. But we're just focusing at the moment on what Lord Hoffman was saying about penalties and fines and the like.
Well, I'm sure very helpfully you've been asking me to focus on one point at a time, but you can't really disengage the point that what von Glen is dealing with is a particular type of fine, or a particular type of penalty, which is different from the Electricity Act. And if your Lordship is suggesting to me that there is some kind of overlay which spreads itself like jelly over the Taxes Acts, I can perhaps understand that in the case of a penalty such as was in von Glen, but I don't understand it in relation to a system which provides for redress payments. And my Lord, look how insidious this is. We are now about to start a debate. Is this a punishment? Is this a penalty? It's got nothing to do with the statute. What we're told to do by Section 54 is ask the single question, is it wholly and exclusively for the purposes of the trade? And I have to accept that there are some payments, not very many, but some payments which, as a matter of law, may not be wholly and exclusively for the purposes of the trade, even though, as a matter of fact, they are. That seems to be what Lord Reid is saying in O'Dowdle, and you also pick that up in Von Glen. But that absolutely can't be the case with a provision that is dealing with the relations between customer and supplier.
Have we got O'Dowdle? Oh, we have got. We've got Dowdle in the.
Yes.
Yeah, thank you.
And
You're fairly making the point that if I think you did accept, obviously we're bound by Von Glen, it applies to fines of that nature.
yeah.
It may apply to actual penalties in this case. But you say on any basis it can't apply to what was paid here.
Yes.
Which is not, the revenue has to accept. There weren't payments that were specifically provided for by the statute, albeit that under the powers as they now exist, as I understand it, a consumer redress order might have been made to similar effect.
It's possible it could have been, but it wasn't. We think consumer redress was referred to in the statement of policy before consumer redress orders came in. But it's undoubtedly different.
Well, with respect, I think that's a different point. I mean, you started your introduction to McKnight with a fanfare that we could read the decision with missing out a big chunk in the middle, and it had nothing to do with policy. I think we've now got to a stage, perhaps, where there may be a legislative justification for penalties in the strict sense in Von Glen and the like not being deductible.
But that may not be on the basis of policy.
If we substitute, because Lord Hoffman, you see, does talk about legislative policy at the foot of page 1337, and that's just simply shorthand for the policy of the legislature as expressed in the statute, isn't it?
I'm a huge fan of Lord Hoffman, I have to say. But this is not the most coherent passage of his that I've ever read. He uses rule and policy in different senses at different parts of the passage. And it's quite difficult to know which rule and which policy comes from and where from. And if this is a rule of interpretation, why doesn't he say it's a rule of interpretation? The First-tier Tribunal thought this was a policy overlay. If it's a policy overlay, it ought to be dead from fender.
I think what would be said is it's the job of the judge, the court, to construe legislation in accordance with the perceived policy of the legislature, Parliament. It's a purposive interpretation of statutes, which seems to be the modern way. It's not a literalistic approach. You have to understand what the purpose of the policy of the statute is. If the policy of the statute is to impose a penalty, a fine, upon a wrongdoer, then aren't Lord Hoffman's statements perfectly understandable that you shouldn't interpret another statute, viz. The Taxes Act, in a way which undermines or as he puts it, dilutes that first legislative purpose.
There's no doubt my fault, but I'm not clear which statute we're interpreting there. But bear in mind...
You're interpreting the taxing statute in such a way that it doesn't undermine the legislative policy behind the Customs War Powers Act or the Don't Speed on Your Way to Work statute, the Road Traffic Act.
But in the context of our case, that assumes that there is a legislative policy in the Electricity Act which is intended to deny a deduction for what are in effect trade damages.
That may be right, but it's a different point, if you're right, isn't it, than the point which I think you're trying to labour here, which is that we should disregard what Lord Hoffman said because he was off on a frolic talking about a judge-made public policy. I put it less elegantly than you did, but that's what you're...
Right, if I may say so. I think your Lordship put it far more elegantly than I did. Well, I do say that, yes. I do say that. And...
you see, you could be wrong on the Lord Hoffman was wrong.
Yes.
But right on the second.
Yes. Yes. And it really is curious. If you look at the Herald and Weekly Tribune case, should we perhaps look at that? It's quite instructive.
Is there anything more you want from Lord Hoffman's speech?
I do make the point that he uses rule and so on in different places, in different senses. So at page 1338, 181 of the bundle.
You see there, I think if you're thinking about the, especially his analysis of the Australian case, Herald and Weekly Times, as I read it at the moment, what he's saying is, in contrast to Von Glen, there is no legislative policy apparent from the requirement that somebody might have to pay damages for defamation, which would be infringed if you allow the defamer to deduct the damages for tax.
Well, but there is a common law policy that you shouldn't defame people. That's why we award damages.
Yes.
And what is the fundamental difference between a common law policy and a legislative policy? Especially if what you're interpreting is Section 54.
But that would take us back to penalties are deductible. Statutory penalties are deductible, if you're right in that submission.
No, because the root is not so deep in the trade. And that is the point that is being made in Herald and Weekly Tribune. It's...
You were going to take us there.
Right. It's tab 13. It's an Australian case. The legislation is broadly the same. And the relevant passage begins on page 280, 118 of the report. But this expenditure, I'm picking it up about the middle of the page. So, if we go to the end of the passage, our payments, in our case, directly flow from acts done for no other purpose than earning revenue, acts forming the essence of the business. And my findings of fact say that, not exactly a coincidence. And this is Mr. Justice Dixon, before he became Chief Justice Dixon, and before whom we all bow the knee. He doesn't treat von Glenn as a case of legislative policy. He deals with it at page 120. He says its nature severs it from the expenses of trading. That's why the fine is not deductible. In von Glenn. But you can't say that the payments I made are severed from the nature of the trading. You can perhaps say that with the fine in von Glenn. You can say it in relation to parking fines, for example. You can get a parking fine whether you're trading or not. You would never ever have paid the parking fine to your customer. The contractual relationship is between A and B. The fine goes from B to C. And the trade is not an essential part of it. But here, we have to answer the telephone. We are required by law to answer the telephone in the course of our trade. If we don't do it quick enough, a penalty can be imposed. If we don't do it quick enough, the regulator can come and agree a deal which involves a small penalty, but the purpose of which is to compensate. And here is this payment. If we took the regulator out of the picture and these payments had been made, you can perfectly well imagine these payments or payments like these being made, certainly the ones that were designated to the warm home discount customers. And it is being said that the taxpayer doesn't get a deduction for them. I appreciate it has been said, but frankly, it's commercially absurd. That isn't necessarily so of fines. They do have a different character. I can see that. But these, if you stand back at them, look at them, they have every incident of a normal trading payment. I gave you 8 reasons why that was so this morning. They're different from the fines and penalties. And really, in our submission, they ought to be deductible. Otherwise, we're not taxing the right profit. We don't actually know what policy there is in the Electricity Act. If your Lordship says there is a policy in the Electricity Act that payments made with the encouragement of the regulator are non-deductible. That seems to be rather too loose a rule to be comfortable. What's meant by with encouragement of the regulator?
Well, I think you need to take it in stages. I know you don't like the fact that I might want to try and untangle some of the submissions. There's a policy, let's say there's a policy in the Electricity Act that says you shouldn't missell tariffs to customers. And if you do, the regulator can fine you because you have misled customers. If that were the case and a penalty was imposed upon you and you went through the rigmarole of an appeal and failed on your appeal and had to pay, would the policy of deterring regulated entities from misleading customers not be undermined if they were entitled to deduct that fine, that penalty, from their income for the purposes of assessing tax, profits to tax?
I would have thought that if that was the policy of the legislation, it would say so. It's a very odd thing to...
It didn't say it in, none of the statutes that we've been looking at say it explicitly.
The explanation I would give for those cases is that as I submitted earlier, there's a two-stage process you have to go through. You have to find out what the purpose of the expenditure was and whether everything was wholly and exclusively for that purpose. And then you have to ask, is there any reason of law which comes out of the interpretation of Section 54 of the Corporation Tax Act that prohibits the deduction because of the meaning that is being put on the word expense? And Mr. Justice Rolat says at the beginning, he warns that the question is whether it's commercially contemplable. And I do think that's a good guide. It's why I began with a paean of praise for Mr. Justice Rolat. He does actually know the answer to these things. He did know the answer. And that's a very good answer. Is this commercial? Can you imagine something like this happening in the ordinary course of a trade? And we know in this case the answer is yes. And I'm conscious, I feel that as I respond to your lordship, I hop from one leg to the other. I'm aware of that. But that is because the cases don't speak with one voice. It may be that we all know why we all know that the speeding fine should not be deducted. It may be that we all know that. If we went around the room, we might find 20 different reasons as to why it shouldn't be deducted. The cases aren't unanimous on that. And Lord Hoffman's attempt to synthesize them is, quite honestly, it's an attempt to launch a boat which appears rather leaky. It's very difficult to envisage a non-tax statute containing a tax rule which is not express, but which I conjure out of the air, contrary to what Fender says. And that is possibly why one steers away from arguing about penalties. But I don't have to argue about penalties because these aren't penalties. I don't have to argue about punishment because this was an agreed settlement. to compensate. I found it, when I sat down to write my argument for this hearing, I found myself starting with the concept of penalty and punishment, because to a large extent that is what the FTT decision of the Upper Tribunal decision is about. And then I say to myself, well, hang on, where's this in the statute? In, if I may say, my statute, the Taxes Act, section 54. Where do I find these concepts? And how am I going to define them? And I've got pages of it in this judgment. Oh, is this a punishment? You're meant to be able to look at a set of accounts and say the profit is X, not go agonizing. Oh, is this a punishment? Is it a penalty? Is it in lieu of it? Do I make an overall assessment? Is it an evaluative judgment? This isn't the way we determine the subject matter of taxation.
But the difficulty with saying that is that there is somebody involved before you get to, as it were, thump your fist on the accounts, because somebody has to draw them up. And they have to do so, don't they, in accordance with generally accepted accounting practice, but subject to any adjustment required or authorised by law.
Well, the accounts are first drawn up without the adjustment. Then you make the adjustment after you've got the profit figure from the accounts.
But if, well, that's the profits of a trade must be calculated, so I'm not sure that's right. But in calculating the profits, the auditor, or the accountant, has to decide what items can be set against the income. And so the accountant has to make a judgment in accordance with law.
It's very annoying to the lawyers that the statute gives primacy to the accountants. It's very, very annoying.
I don't have a problem with accountants. They're very nice people.
It doesn't, does it, prohibit the accountants if applying normal accounting principles to make certain deductions or provisions, many of which may not be allowable for tax purposes.
Yes.
The adjustments required by law are those that you make in doing your tax computation.
Yes.
So they're adjustments to the profit. So
Yeah.
typically you start with the profit in the accounts, you then make certain adjustments.
Yes.
And one set of those adjustments, there are lots, it could be capital expenditure, general provisions, whatever, but one set would be for expenditure which might be properly taken into account in preparing accounts, but which may not be wholly and exclusively.
Yes. And I am not standing here and saying, oh, you're not taxing the commercial profit. You're not taxing the company profit, rather. I notice that whinge occurs on Glen and in Warnes. I'm trying to avoid that whinge. I'm saying you're not taxing what I shall call the commercial profit. You have to start with the commercial profit. And in context of this case, you can only then deny the deduction for something that, as a matter of fact, is neither wholly and exclusively, or, as a matter of law, is prohibited from being deducted. And the learned friend is going to say it's prohibited from being deducted by a rule of law. But
Yes, the Section 54 is one of those rules of law. I think what HMRC are saying against you is that there is another rule of law which applies in this case.
Well, I'm not sure if they're saying that there's another rule of law, or if they're saying it's a matter of interpreting the word expenses in Section 54.
Well, here.
The point that those two possibilities exist is significant, because after living with this case for 4 or 5 years now, I am not clear what rule the Revenue are asserting, whether it is that it's a matter of interpretation of Section 54 or that it's a matter of policy. What I do know is that the First-tier Tribunal and the Upper Tribunal are disagreed on the point as to what it is. And where you get that type of disagreement, it is at least a possibility that there is no rule in existence. Now, if there is a rule in existence, that it certainly isn't clear enough that you can use it to deny a deduction for these profits, these expenses.
Just for my benefit, when you say they disagreed, obviously they disagreed as regards £500,000, but I think you're making a more fundamental point about the nature of their disagreement.
Let me just find the passages. So at paragraphs 136 to 142 of the FTT decision, the FTT says it's a matter of policy. And in the Upper Tribunal, it's paragraph 51.
Thank you very much. Okay, yes, I understand.
See, the Upper Tribunal says Lord Hoffman was simply engaged in the orthodox conventional task of construing the material part of the statute, section 130A. But it doesn't say which bit of 130A it's construing. Well, my lady, unless I can help you further, those are my submissions.
Thank you very much.
Well before
tea. Yes, Mr. Yoder.
Can I begin by clarifying what our case is, because that's what you've just been debating with my learned friend, and he claimed not to understand what our case is. We set it out in paragraphs 14 and 15 of our skeleton, perhaps 16. Our primary case is that what Lord Hoffman was doing in McKnight was interpreting what is now Section 54, that was then Section 130A, I think, of the Income and Corporation Taxes Act. He was interpreting that so as not to permit a payment to be deductible if it would offend public policy in the very specific sense that it would dilute the effect of a fine or penalty.
Did he use the word public policy or legislative policy?
Policy, I think
He certainly
yes.
used legislative policy.
Yes. It's the policy
I
of.
can't remember him using the word public policy, and I do wonder whether we might.
Well, yeah, we can look at that. Certainly, that he's referring to. There is a general public policy that if you are fined or subject to a penalty, then you should have to bear the whole of that fine or penalty, and not share it with the, as I think your lordship said, not share it with the rest of the tax-paying population.
But when he says legislative policy, I mean he's talking about a policy as evident from the legislation,
Which imposes the penalty.
Yes, but he's not purporting to set out his own view of public policy, is he? The trouble is, if you to use a cricketing analogy, which I seem to have started with this, if you hang your bat out by using the expression public policy, you might just edge it to the slips.
Yes. Well, but I think it's a general policy that he would identify whenever there is a penalty or a fine, that it should be borne and not be shared. I think that is the policy. I'll come to look what he actually says, but we would suggest that that's a general policy. He's not restricting it just to the particular legislation in question in that case, for instance.
Well, we need to be quite careful about this because I think Mr. Goldberg's submissions essentially to you are show me the statute.
Yes, and
and if that's what Lord Hoffman is actually saying, and you can't, then he wins.
Well, except that's we would submit that's not a conclusion that's open to this court,
Right.
because Lord Hoffman has, well, not just Lord Hoffman, a unanimous House of Lords have laid down this as a matter of interpretation of. First of all, a primary submission is as a matter of interpretation of Section 54 as it is now.
Yes.
But the alternative
Yeah, I mean,
is that it's a judge-made, what you call a judge-made rule, a rule of law.
But Lord
That would
Hoffman expressly refers to non-deductibility depends on the nature, I'm reading from page 181, nature of the expenditure and the specific policy of the rule under which it became payable, it being the final penalty.
Yes. The
So
policy.
it appears to direct attention to the particular policy of a rule, a legislative rule that imposes a fine or penalty,
Yes.
rather than some sort of broad, general public policy.
Yes, that's correct. But I would also submit that what he was saying has more general application than just to the rule in that particular case. I don't think anyone has suggested that it only applies
No, I don't.
to the rule in the stock exchange.
No, the question being asked more is are you looking at some sort of general public policy, or are you looking at a specific policy? At least in that section,
Yeah.
he seems to be focusing on the particular statutory provision.
But that policy being that the policy of the legislature, this is legislation which imposed a penalty or a fine. And the policy that he's referring to is the policy that fine or penalty should not be diluted, because the deterrent effect, etc., would obviously be diluted and perhaps lost. So the policy that he's referring to is a policy that those fines should be paid gross, borne gross by the person who is subject to them. That is what I would submit he's referring to.
So it's a policy that derives from the act in question, but it's a policy that would be replicated every time you find an act which imposes a penalty.
Exactly. So in that sense, it's maybe public policy is the wrong word to use, but certainly it's a general it's a general policy you will find in relation to, because he applies it also to Van Glen. The provision there, he says that's the explanation for Van Glen, that it derived from the policy of that particular act, which imposed a fine over. There seemed to be some doubt as to whether it was criminal or not in Van Glen. It was sort of quasi-criminal, I think, the fine. But anyway, a fine.
You see, what he might be said to be doing
breaching the regulation
is, as my lady pointed out at 181B, he talks about the specific policy of the rule under which it became payable, namely the expenditure. And he says where the expenditure is a penalty or fine levied by an act of Parliament or some delegated legislation thereunder, there is a legislative policy, which is the expression he uses at the bottom of page 1337, which you shouldn't dilute by allowing the taxpayer or the wrongdoer to set it off against tax. And see, I don't have difficulty with that if you are talking about penalties in the strict sense, the £1 in this case. But that's not, as has become very obvious, that's not the real bone of contention between you. The bone of contention is something that was not levelled as a £1 penalty, but a £18 million something else.
Yes.
And the challenge to you that I think Mr. Goldberg has laid down, in essence, is show us the equivalent policy, legislative policy, that would be undermined if his client was allowed to treat it like, he says, any other expense that they incur solely and exclusively for the purposes of their business in dealing with their customers.
Yes. And I was going to deal with that. That seems to me, in my submission with respect to my learned friend, that is the point that is open to him in this court. What we would submit is not open to him is to take issue with what Lord Hoffman said and decided in McKnight. So the background to what we're going to discuss about the payments in lieu of the penalties, we would say, has to be informed by what Lord Hoffman says in McKnight is the policy that would be offended by allowing a deduction.
Now, you started this session by saying that your primary way of putting this is a matter of construction of Section 54. How do you read Section 54? What is it you read into it? What words are there that aren't expressly there? How are we supposed to look at it?
Well, that's why we have the alternative. Our alternative.
Well, because you can't answer that question.
Well, maybe it's a question for Lord Hoffman, because what we would say is if you analyse this judgment, it's quite clear that Lord Hoffman is dealing with an argument about what was then Section 130 in this case. So it is by implication his interpretation of Section 130. Can I just show you that? If you look at the structure of the judgment, my learned friend started it on page 179 at the bottom, Mr. Grabiner's second point, but it is helpful, I think, to look at the first point, because the revenue had 2 points, both of which related to Section 130.
Well, is it better to start with the first paragraph of his judgment?
Probably, yeah.
The question is whether the deduction of these expenses is excluded by Section
Yes.
130.
So that's the context.
That's the issue he thinks he's addressing.
Exactly. And the revenue had 2 arguments in relation to the costs. One was duality of purpose. on the basis of the findings of the Special Commissioner. And that was Mr. Grabiner's first point, that there were two purposes. And Lord Hoffman deals with that up until letter H on page 179. Essentially, he's saying this is another example of the kind of case put forward by Lord Brightman in Mallow and Drummond about the consultant who went to visit his client in the south of France on the question whether he could deduct his airfares and presumably his hotel bills and his wine bills.
I think he's staying with his friend, so he gets.
He's staying with his friend.
Free and gratis.
Yes, anyway, his travel expenses, and the point that he's making is a common point, which is that if he's believed that his sole object was to go and visit a client, and that's accepted as a matter of fact, then he'd only have one purpose. Although, of course, an effect of it would be that he would have a nice time sitting in the south of France. And Lord Hoffman said that there wasn't duality of purpose in this case. So that was the first objection. But the second objection was based on Von Glen, which of course was also a case. Perhaps I'll show you that in a moment. There was also a case about the forerunner of Section 130. It was about the wholly and exclusively rule as well. The provision to which they were applying in Von Glen was Section 130, but a predecessor of it. So the revenue were relying on Von Glen and saying, well, this is similar purpose. There's the same purpose to the costs as there are to the penalty. And of course, that's what had been decided in Von Glen. In Von Glen, the costs were not allowed either, if you remember, as well as the penalty. I think he says that in the judgment.
But he disagrees with the court.
But he disagrees with that, and indeed the judge in this case had decided that the costs went with the penalty. Mr. Justice Lyman, at first instance, well, on appeal from the Special Commissioners. So he's dealing with this point that the purpose is the same, essentially, of the costs. If the penalty is paid not wholly and exclusively for the purpose of the trade, the costs are also not paid wholly and exclusively for the purpose of the trade. And it's in that context that he analyses Von Glen and concludes that they were looking in the wrong place, perhaps, in the Court of Appeal in Von Glen. What they should have been looking at was the nature of the payment. And then he goes on to talk about the questions of policy and explains that his explanation for the decision in Von Glen is that it would be based on the policy of the legislation which imposed the penalty. The purpose being to punish the taxpayer, and he says a court may easily conclude that the legislative policy would be diluted if the taxpayer were allowed to share the burden with the rest of the community by deduction for the purposes of tax.
What do you think he's referring to when he says legislative policy?
I think it's a policy of the Act which imposes the final penalty. Because the policy of that Act must be that a fine is imposed partially as a punishment, but that can break down into deterrence being a very important part of it. So, as in the present case, it was important that the penalty was seen to exceed any benefit which the company might have got from not complying with the regulations.
Isn't it slightly simpler than that? Is if you're fined, it's you that has to bear the burden, and you can't pass it to everybody else in the courtroom by claiming it against your tax, which is collected on behalf of society at large.
But the reason why, perhaps just thinking a little deeper, perhaps the reason why you can't share it is because punishment, penalties and fines are calibrated, at least in theory, to punish at a particular level, and you have to pay it all. That's the point.
Yes, but punish you.
Punishing you, yes.
The person.
Yeah, yes.
And that's what he means by you can't share the burden with the rest of the community.
And that may be what was meant by the metaphor of in Lord Stendale, where he said the fine was imposed upon the company personally.
Yes.
You see? Yeah.
And despite you looking at the legislative policy of the provision that imposes the fine, Lord Hoffman, you say, is still interpreting Section 130. And indeed, even at the beginning of this question, start of the end of 179, he appears to be interpreting the words for the purposes of the trade.
Yes. So he's dealing with an argument based on Section 130 by the revenue. So he must be, we would submit, must be interpreting Section 130. He doesn't say so in so many words.
But trying to, because we've got this legislative policy where you're looking at one particular statute, and we now say we're interpreting Section 130. So how does that interpretation go? Is it something like, when you're interpreting Section 130, you have to take account of the legislative policy of statutes that impose fines and penalties, and their evident policy that those should be borne entirely by the person fined or penalised?
Yes, because that's why he talks about the nature of the payment. So he's saying the nature of the payment is a fine or a penalty. So that's the important thing, rather than focusing on the subjective purposes or any of the purposes of the taxpayer.
Although curiously, at the top of page 180, just below B, when he's actually discussing on Glenn, he does say that Lord Sterndale, I'll have to look at this, said that although the incurring of the penalty was connected with the trade in the sense it wouldn't have happened unless the trade was carried on, it was not for the purposes of the trade, but because of a wrongful act on the part of the company. And that seems to be another. I mean, is that an attempted joinder, the link? You have a wrongful act here which Parliament has decided to penalise. It's implicit in the concept of a penalty that it's to be borne solely by the person on whom it is imposed. And the justification is that you must then interpret Section 130 or its equivalent, that it is not, that payment is not for the purposes of trade, but because of a wrongful act on the part of the taxpayer.
Well,
I mean, I'm just trying to string together.
I don't think you can go as far, because there are some authorities about cases where the taxpayer does a wrongful act that is so far out that it's not part of the trade. That's not this case. So, for instance, McLaren, for instance, where they were trying to steal secrets from the other people.
Yes, or I mean, if you set up a newspaper and decided to do so solely for the purposes of defaming somebody, I suppose it might be said. Could it be said that that would be, you did a publication that had no other purpose? I mean, we've got a newspaper, on the face of it, an authentic newspaper, which just in the ordinary course of conducting its business just happens to get sued from time to time. But if you set up a publication for the simple purpose of defaming somebody, you might not be able, presumably, to deduct the defamation damages.
Well, I don't know about that.
Private Eye doesn't.
I was going to say, you don't really want the editor of Private Eye listening to that.
All of the examples sound a bit fanciful, although they end up happening in cases like McLaren. But I imagine a case, for instance, where a mining company decided to take out a hit on one of its competitors. That would be outside the trade. It's not a way of conducting its trade. I mean, killing.
Well, I mean, there have been.
That has happened as well.
I mean, there have been occasions in the past where business entities have published, journals or made publications to attack their commercial rivals. They'd have, because sorry, you're being passed something, so don't ignore it. But
yes.
Anyway,
Anyway,
we're going to have to try and join some of these threads together, because
But that's not that. Yeah, well, that's not the way. That's certainly not what Lord Hoffman's talking about here. It's accepted that Mr. McKnight was carrying on, was not going outside his trade in what he did. It certainly wasn't. Sorry. Oh, sorry, was it Mr. Shepherd? Sorry, Mr. Shepherd wasn't going outside his trade. In this case, that wasn't the argument that was being put forward. Otherwise, it would have been a very different case. And similarly, not in the present case, it's not being argued that what they did went so far as to be outside the trade. So, focusing on the wrongful act, well, it's a wrongful act which results in a fine, I suppose. I mean, what has to be clear that you cannot extract what Lord Hoffman said out of the judgments in Glen. This is, I think it has to be said, Lord Hoffman's explanation as to why the case was correctly decided. But none the worse for that, we would submit. It is undoubtedly part of the ratio of the decision and binding on this court. And much of what my learned friend said earlier, I would suggest is really a rehearsal for a higher court if it ever got there, because it's not open to this court to say not just Lord Hoffman, but the entire House of Lords were wrong about this in our submission.
But so far,
We're wrong about the principles to be applied.
so far in answering my question about how one is construing Section 54, you've thrown the problem back on Lord Hoffman to say, well, if it's a problem here, it's a problem there. And I can't see in the judgment of Lord Hoffman where the circle is squared.
I don't think he's saying, he certainly hasn't said, look, there's the word that you latch onto. I think it's a broader principle of statutory construction, which is that you have to construe legislation so as not to confound the policy of other legislation. I was trying to think of analogies. I'm not sure how good it is, but there is a principle, maybe you're familiar with, that what the courts have applied where statute can't be used as an engine of fraud, you remember. That's a case where if you applied the statutory provisions literally, it would promote a fraud. And the courts have said, well, you can't do that. They're not construing any particular words, I don't think, in the section. They're just saying that that's a general principle. You cannot rely on a statutory provision in order to obtain that.
It doesn't seem a particularly, at least at the moment, it doesn't seem a particularly adventurous submission to me to say that you should, where possible, interpret parliamentary statutes consistently with each other. So if you can find a way of interpreting one statute so as not to undermine the legislative purpose of another, you should adopt that interpretation. I mean, if that's a proposition, I suspect there's somewhere in Benyon, in the vast swathes of Benyon, I'm sure there's something to that effect.
Yes.
But I think that's really what you're saying, rather than latching onto any particular words in what is now Section 54.
Exactly, yes. And that's what I think Lord Hoffman was saying. Now, there is a fallback of that, which is the possibility that Section 46 can be subject to rules of law, not statutory, but judge-made. And that's recognised in the NCL case, which another friend, I think, took you to the Supreme Court. And this could be arguably an example, one of the rare examples of that. It would be a judge-made principle, exactly along the lines that your Lordship has stated, that statutes, this particular statute, or all statutes, must be construed so as not to confound the policies of other statutes. In particular, statutes which impose fines and penalties. So this is a very particular type of policy that Lord Hoffman has identified. it isn't anything remotely similar to what happened in Fender, which my learned friend took you to, although only briefly. I don't know whether you've read any of that case, but it's in a completely different area. It concerns the question of whether a contract to marry is contrary to public policy that it was entered into between the decree nisi and the decree absolute. And there was law that said that you couldn't enter into it during the marriage. The question was whether there was a difference between that and cases after the decree nisi, and the majority held there was, and that it was a valid contract, whereas the minority said it wasn't, and that but this was all based on very broad policy, morality, the sanctity of marriage and things like that, which is the context, I think, which Lord Atkin was speaking in that case. But here we have a very particular, and we would submit, obviously correct, obviously justifiable policy that Lord Hoffman has indicated. So the question really is, how does that policy apply to the facts of the present case?
You said it's obviously ratio, and we've heard the argument.
Yes.
Contrary. Are you going to explain further why you...
Yes, I certainly can. I thought it was telling that my learned friend couldn't, in fact, incise anything from this decision. It's quite obvious he can't. It's ratio because it is an essential part of the reasoning of Lord Hoffman in coming to his conclusion about the costs. The reason which he said, the reason why, so that's the starting point, is that he was answering an argument based on Von Glen. That the purpose, it was said, of the incurring the costs was the same purpose as that of incurring the fine or the penalty. And his answer to that was, let's look at why. Let's see why, in fact, the fine is not deductible. The reason has nothing to do with the purposes of the taxpayer. It's to do with the nature of the payment, is what he says. So the Court of Appeal were looking in the wrong place. It's the nature of the payment. The nature of that payment is a fine, and then he talks about the policy of the legislation imposing the fine. And then he contrasts that with the position as regards the costs. That policy doesn't apply, he says, to the costs. Indeed, I think he says at one stage the converse would be the case almost. That if you didn't allow them to be deducted, that would act as a further penalty on the taxpayer.
That's the end of 181.
Yes. So the reason the costs are deductible is because of the policy being different from the policy of the fine. So that's why we would submit it. It's slap bang in the ratio. You cannot understand, you cannot come to the conclusion that they came to at the end, as set out in the head note, without going through those stages of reasoning. So we would submit it is binding. But of course, it's only binding in relation to, well, what is binding is stating the policy that you might identify, and of course applying it in relation to fines, actual fines. So the question that you have to address is really whether there is a difference between a penalty that was imposed by the regulator in this case, so if the £1 or any amount the regulator had actually imposed formally as a penalty, and the amount that was paid under the agreement that was entered into between Scottish Power and the regulator. Before I deal with that, can I just deal with one other point in relation to the authorities? Because rather surprisingly, my learned friend, the linchpin of his case seemed to be a decision of Mr. Justice Rowlatt, which wasn't in the bundle, which is the case of Warren. And can I just point something?
Well,
quite
it is, I think to be fair, Warren is approved in Von Glen, isn't it?
Well, no,
Will you say it isn't?
it isn't. Because Warren was a case not about what is now Section 54 at all. It was a case about the provision about loss. And you can see that if you look at...
Well, that's the other limb of 54, isn't it?
It's the other limb, but it's importantly different limb.
And just to be absolutely clear, because Von Glen discusses both limbs,
Yes,
the revenues case rests solely on the wholly and exclusively, does it?
yes, because in Von Glen, two of the Court of Appeal expressly said they didn't think that this limb applied. I'll take you to that briefly. The loss provision. So it's a loss. You can see that near the end. He says it cannot be said that it's a loss, in inverted commas, connected with or arising out of the trade within the meaning of this rule. And all the things he says about the nature of the loss, which is contemplable, and the nature of the commercial loss, are all in the context of that rule, which talks about it being a loss connected with or arising out of the trade. So you can see why you might talk about it being a loss which is contemplable in that context. And if we then go to, so Warren was a case which he decided, and then he then heard Von Glen as first instance, and he applied.
Yeah,
his
I recall there's only a two-line judgment.
I think that's probably,
As usual, we haven't got
it's covered.
it in the bundle.
Yes, but it is summarised at the beginning of Von Glen. If you look at page 52, where it says that near the bottom, the Special Commissioner has found the final loss were incurred by the respondents in the course of carrying on the trade were incidental thereto and decided that they were admissible. The Crown appealed. Mr. Justice Rowlatt followed his own decision in Inland Revenue Commissioners and Warren, held that the final loss was not a loss connected with or arising out of the trade or business within 03, therefore was not a deduction. So then if we look at what the Court of Appeal said, page page 62, Lord Sterndale at the top, he refers to the word loss in Rule 3 means what is usually known as a loss in trading or in speculation. It contemplates a case in which the result of the trading or adventure is a loss, wholly or partially, of the capital employed in it. I doubt whether the damages in the present case can probably be called a trading loss. I prefer to decide the case upon Rule 1, which applies to profits, and that's for the purposes of the trade rule. When he refers to the damages, he means what's sometimes called a fine, I think. It was a slightly unusual process. I think they were collected in the High Court, as far as I can see. The Attorney General appeared in the case. And then Lord Justice Warrington said the same thing in the middle of page 66. where he says, among the things that may be allowed, I think, is a loss connected with or arising out of such trade, manufacture, adventure, or concern. Now, is the expenditure in this case a loss connected with or arising out of a trade or adventure, manufacture? It arises out of the trade, I mean, we concede it does not arise out of the trade because if it had not been that the company was carrying on the trade, they would not have had to incur the expenditure. But in my opinion, it's not a loss connected with or arising out of the trade. It is a sum which the persons conducting the trade have to pay because in conducting it they have so acted to render themselves liable to this penalty. It's not a commercial loss. I think when the Act speaks of a loss connected with arising out of trade, it means a commercial loss. And then he goes on to deal with Rule 1. So he says it's not in Rule 3 or Rule 1. So I don't think it's right to say that Mr. Justice Rowlatt was approved. In fact, the very opposite. Lord Justice Scrutton doesn't expressly deal with Rule 3. He simply goes straight to Rule 1 and deals with that.
Hang on, sorry. Sorry, did I mishear you?
Yeah.
The last sentence of Lord Sterndale's judgment is, I think the decision of Mr. Justice Rowlatt in this case and in his decision in Warnes, which he followed, were right.
Well, the decision was right, but not based on the provision that he was basing them on.
Okay, so you're drawing a... Right, okay.
It wasn't approved in that sense. It was upheld.
Sorry, just going back to Lord Justice Warrington, he does consider both elements, doesn't he?
He does, and
But
says...
you're saying that the other two judges preferred to rely on Rule 1. Is that right?
Yes, he says it's not within Rule 3. As does Lord Justice...
Sorry,
Lord Sterndale also says...
I'm getting confused with the nots. Not within the prohibition in Rule 3. It means it would be deductible.
Well, I think he was looking at it the other way around. I think he was looking at it whether...
He says it's not a loss connected with or arising out of the trade, suggests he thought a deduction could be denied on that basis. Anyway.
It is quite strange. I agree with you. When reading that, I wondered why he went on to look at Rule 3. But he did. He thought it wasn't prohibited by Rule 1. He thought it wasn't prohibited by Rule 3.
Although it may not therefore be a deduction, that's beyond me.
Not prohibited by Rule 3.
Too many negatives.
Yes. For some reason, he didn't think that Rule 3 applied. And he then looked at Rule 1 and decided that that applied to deny deduction.
But in any event, in this case, HMRC are relying only on wholly and exclusively.
Yes. I mean, yes. I may check this. It may be that Rule 3 in those days was positive rather than negative.
I think it's set out.
So if you got within it, you got the deduction, but if you didn't get within it, you weren't prohibited. I think that may be the case. But that doesn't make much sense of Mr. Justice Rowlatt to say. Anyway. My point was simply that, in any event, Mr. Justice Rowlatt wasn't saying anything in Warren that was of relevance to the statutory provision that we were looking at. So, moving then on to the question of applying these principles to the present case. And can I then just take you then to tab 20 in the supplementary bundle? This is a letter that you looked at already. and this indicates the position that Ofgem were taking.
Are you going to take us through at some point before we actually get to look at the letter, were you planning to take us through the regulatory regime that Ofgem were working to at this time?
I can do that now, actually. That might be a good idea. I'll take you I want to begin with the Electricity Act, in fact, which is, I think, in the bundle, perhaps to explain.
We've only got the Electricity Act in the bundle. Should we assume that the gas equivalent is precisely the same?
I have assumed that, but I haven't checked. And penalties are dealt with, section 27A. And the authority, first of all, has to be satisfied that the regulated person has contravened or is contravening relevant conditions or requirements, or has failed to achieve any standard of performance prescribed under section 39 to 39A. And it then states the authority may impose on the regulated person a penalty of such amount as is reasonable in all the circumstances of the case. And you may have noticed in the notice which you've been shown that the regulator says that they regard the £1 penalty as being reasonable in all the circumstances of the case. Now, my understanding is that the cleverness in all this in relation to Ofgem was that they were in a position where the only power that they could exercise at the time we're talking about was the power under this section. But what they alighted on was that one of the circumstances of the case might be an agreement between them and the regulated person to make certain payments. And that's what I understand that their reference in the notice to the penalty being reasonable in all the circumstances of the case is that one of the circumstances is that the regulated person has agreed with the Ofgem to make these payments. Otherwise, they wouldn't be in a position to reduce the penalty on the grounds that they had made payment or agreed to make payments, for instance, to a charity or to customers, etc. And then you also notice subsection 3, where the authority has to give notice and also has to consider any representations or objections which are duly made and not withdrawn to the penalty. And that's why you have that rather odd, I think, where you have that rather odd notice which says that they will be looking for representations or objections, even though they're imposing a £1 penalty. Because I think there is a statutory requirement in relation to the penalty to consider representations or objections which are made. Of course, I suppose it's possible that someone else might have made a representation that it wasn't appropriate to.
This isn't a notice just given to the regulated persons. This is a published notice.
The notice, yes, because it allows representations generally.
Oh, well,
yeah, yes. So it is possible other parties might make representations as to the penalty, I guess.
Yes, subsection 7 deals with publication.
Yes.
So even the sort of intention, the intended penalty under subsection 3 is notified publicly.
I think it has to be because then they have to consider representations in relation to that before opposing it.
So what we were shown earlier, which was appended to the settlement agreement, is actually the first step in this process. Then it's the notice under 27A1(3).
I think it must
Which
be.
is designed to attract representation.
To try representations, yes. That was the way I understood the process. So as my lady quite rightly said, there are provisions in subsection 7 as to where the notice has to be published.
I mean, this is drafted on the assumption that there's a war. You know, the regulator says, you've done something wrong, we're going to impose a penalty on you, we're publishing our intent. And then the world has the chance, well not the world, but everybody who has an interest in it has the chance to say, yeah, go for it, or that's outrageous, da-da-da-da-da. And then the regulator actually imposes the penalty. What in fact happened in the instant case is that there was a sort of pre-process discussion, which came out of the investigation. So, as I understand it, Ofgem say, look, we've conducted an investigation, you know about this. This is what we think's happened. And we are minded to issue a notice stating under section 27A3, stating we're going to impose a penalty, but you can do a sort of agreement with us beforehand if you want, on different terms.
That's the letter you're referring to, 23rd March.
That's the sort of, so in a sense there's been a pre-statutory framework, although we start with 27A, there's actually a pre-process which isn't really contemplated by this section 27A.
Well, except it's part of
it's not outlawed, but it's not outlawed by it, but it's not provided for.
Not explicitly, except to the extent that there is an investigation.
Yes, but section 27A doesn't deal with investigations.
No.
Because it kicks off where the authority is satisfied
that they've contravened, yes.
Yeah. So, by definition, it's not dealing with the investigation. There's presumably another section somewhere in the Act that deals with investigation.
It's the result of the investigation.
Yeah.
They've got to the stage. And that's the stage they've got to by the 26th of March 2016 in relation to this particular infringement, because they are...
So there's an investigation, a process, and then right at the end, somebody runs a £1 penalty through section 27A, which is what they have to do for £1.
They don't have to do it for £1, but yes,
they do, because they can't impose a penalty on a regulated person lawfully without going through the process in section 27A.
Oh, sorry, yes, that's what you mean. Yes, they have to go through the process of section 27A for any penalty, exactly.
I mean, if they'd decided, forget it, for £1, they wouldn't have had to go through section 27A, would they?
Well, but the point about it's not the forget it for £1, because part of what they would be notifying under 27(1)A would be the circumstances, which would be the agreement to make these other payments. Because someone looking at the notice would have to understand that they're not just being charged £1.
You see, I mean, Mr. Goldberg was sort of saying to us, look, suppose Ofgem starts an investigation because they believe there may have been breaches. And as soon as they start it, people at Scottish Power wake up and say, oh, goodness me, hands up, we're just going to make a whole load of payments to customers, charity, you name it. We want to, that's what we're going to do. Here's £17,999,999, which we're going to dispose of in this way. Then you wouldn't have had to go through anything to do with section 27A unless Ofgem decided that they wanted to impose a £1 penalty.
Well, they would have to, in a sense, apply subsection 1 to decide the amount of the penalty as is reasonable in all the circumstances, and if the circumstances were that, as you posit, that they had done a lot of things up till now, they may decide that in those circumstances they don't impose a penalty, or they impose
the word may means may. They may just.
They may.
So Mr. Goldberg is really saying, well,
May or may not, yeah.
in such circumstances, if they'd have voluntarily decided to compensate
In order to
customers,
avoid the penalty.
to avoid the whole being dragged through a Section 27A public process where they are at least fined £1, then he said, why? What distinguishes that commercial decision from any other commercial decision to refund a customer who happens to get through and says you've overcharged me?
Well, depending, let's just break this down. Are you positing that they would, because obviously some of these breaches are not such that you would be able to repay the customers. They're not that kind of breach. For instance, not answering the telephone in time is not the kind of thing that you can say a customer has suffered some kind of loss, and therefore we'll pay them. So you would be making some kind of reparation payment to mark the fact that you hadn't answered the telephone quickly enough.
Yeah.
And if the regulator accepted that and said, well, we won't impose a penalty on you because you've done that, in my submission, it's difficult to see, given the policy that Lord Hoffman talks about, why that would be any different from a situation where it goes the other way around, that they say we're minded to impose a penalty, but if you agree to this, then we'll impose a £1 penalty as long as you agree to do these things. Both of these, the same policy applies because these are things which the regulator has agreed in place of the penalty.
Oh, okay. So
Not in order to satisfy commercial whatever substance of the commercial desires of the company, but as a substitute for the penalty.
So what do you articulate as the scope of the principle? Because one of the points was just put to you was before the regulator even is halfway through their investigation, the supplier has put his hands up and said, no, please stop, we're going to pay a lot of money to charity. I don't think you're necessarily articulating what you say as the policy is necessarily covering that. You're saying something I think is a bit narrower, that if it is instead of a penalty, or can be seen to be instead of a penalty,
Exactly. Yeah.
then Lord Hoffman's principle, House of Lords principle, as you would say it is, applies. If that's right, I think I'd want to understand better what that concept of instead of a penalty is. And I know we haven't got it in this case, but I'm conscious, I don't think it's that easy to ignore when the policy statement directly deals with it. We have got this beast called consumer redress orders now. The policy statement, the only one we've got in which you accept, does cover consumer redress orders as well as penalties, appears on a quick read to put these sort of voluntary redress payments that were made in this case in rather the same bucket as a consumer redress order. It seems to suggest that the policies are very similar in relation to them. So
could we just look?
The
It might just be helpful to look at what consumer redress orders are. They're in the
statute.
They're in the statute here, and in particular the remedial action that can be ordered, which is section 27H.
Yeah. Yes.
They're narrower.
Well,
than the
you
penalty.
say that, but then look at what Ofgem's stated policy is. It thinks that power is wide enough to enable it to require payments to charities and other third parties, just as with voluntary redress payments.
As to require them or to agree them in place of it. To agree.
I would suggest it's worth thinking about the actual policy statement that.
But in any event, the Act provides what they can actually do legally is includes in particular, it says. Now, presumably that means it can include other things.
Well, I think that may be what they were on.
Yes, but it specifically refers to compensation, paying an amount to each affected consumer. So it's not talking about the kind of things we have mostly in this case, which are global.
Yes.
It's talking about an affected consumer. We have compensation for the loss or damage suffered or inconvenience caused as a result of contraventions. It's very specific.
It may be, but it's apparently not as interpreted.
Yes. And of course, there are other preparing and distributing a written statement. That's a different.
But you must have to take failing to answer the telephone. I mean, that's a breach, which would have affected an indeterminate number of people who tried but couldn't get through. If you were ordering a consumer, and that might be quite a good one to order a consumer redress order, but you could never, as it were, do that practically on the basis that you would only actually pay it to those people who had tried to get through but failed. I mean, you would presumably just say, our telephone lines didn't work for this period. You were all customers during this period. You wouldn't have been able to get through if you'd have tried. And then we would make an Ofgem presumably could say you should pay to your consumers for not having an operative telephone line over this period, a global sum of X divided up amongst all your customers equally.
Well, I'm not sure about that. My understanding is that these are not used very much, these remedial orders, that in fact Ofgem carried on with, even after this, with the
I was just
kind
thinking it as a matter of statutory interpretation.
Yes.
Would you not? I mean,
I wonder whether you would say that was compensation for loss or damage suffered or inconvenience caused. If you're just paying everybody who didn't get, I suppose you're suggesting everybody who said they phoned up and didn't get through in time, some sum of money. It's rather doubtful, but anyway, that's probably not something I want to trespass on, because this is probably a matter for Ofgem and
I'll just refer you to what they seem to think is the position on page 287 to 288 of the supplementary bundle, which is their statement on policy on penalties and consumer redress. 287 to 288. This is in relation 7.4 and 7.5. Yes, it's in relation to consumer redress, but it's also, these paragraphs are also cross-referred to in the section that deals with voluntary payments, which is our case. So, to the extent we are looking at legislative policy in the Electricity Act.
well, you're looking at. I think you're looking at statement of policy by the regulator. Yes.
Well, the authority appears to, at least on those pages my lady's drawn your attention to.
It believes it has those powers.
Well, it does. It's under a heading, the scope of the remedies available under
Yes.
consumer redress orders, and it says quite specifically at the bottom, may require the regulated person to make payments to consumers, including those not directly affected by the contravention.
I'm not sure where this is going. I mean, I would be very reluctant for your lordships to make any decisions about the true construction of consumer redress legislation.
Well,
nobody is represented, and it may be that Scottish Power or other power companies would want to challenge this and say it's wrong. I don't know. I've no idea, but I mean, I just wonder why.
The difficulty is that you're asking us to make a decision about the deductibility of voluntary payments made instead of penalties, put it that way. And we really need to think how far that sort of legislative policy or intention goes. And it isn't necessarily irrelevant to that, but there is also a specific provision now for consumer redress orders.
Well, first of all, it wasn't enforced for most of the period we're talking about. But secondly, it seems to be aimed at something different. I mean, it's not, the policy of that's not necessarily going to be the same as the policy of the penalty regime that we're dealing with.
Indeed, it may not be, but that rather makes my point for me. Let's assume its policy is different from that of penalties.
Maybe.
This policy statement has a lot of comments that effectively put the voluntary payments that we're talking about in a similar category to consumer redress orders.
You mean if they were to be, if in the future they were to come to agreements with power companies, not under Section 27A in relation to penalties, but in relation to consumer redress orders, they make payments to consumers or to charities or whatever.
Yeah, but
what would be the position then?
I may have this wrong, but I believe this policy statement, among other things, says that in fixing the level of a penalty, will take account broadly not only of voluntary payments, but also payments made under consumer redress orders. So where's the,
Oh, sorry, in relation to this particular penalty, they would take account.
No, if you're trying to, I think you're saying there's effectively a general principle that anything paid instead of a penalty should attract the same treatment.
Yes.
Among other things, we need to test what that means, how far it goes. And one of the aspects of that appears to be this specific regime now, in place for at least part of the period, for consumer redress orders.
But the fact that an amount is taken, so let's imagine that there was a payment made under a consumer redress order by the company, and then subsequently there was an inquiry in relation to a penalty under Section 27A, and it was decided that they had breached regulations or whatever, and they said an amount of the penalty, in concluding the amount of the penalty, we will take into account a number of circumstances, including the fact that there has been a consumer redress order in the same area, a relevant one, made already, and they've made redress. That would be right. They would be able to take account of that, but that wouldn't make the payment automatically under it's already been made a penalty or in lieu of a penalty, because we're talking about situations where. Not that you've made the payment in the past or done something in the past and they're taking that into account.
Okay, I think
but they're taking into account because...
I wasn't positing that situation. I was positing a situation where the authority are both considering...
Both at the same time?
And
right, well, yes, okay. I think that may get complicated. Issues may arise if they're doing that. But
yes, maybe this does no more than illustrate the difficulty of the question. And whether, as you say, it does apply.
In some cases, maybe it will. Maybe there will be problems in some cases in identifying whether it was paid in lieu or in place of a penalty. But there's no difficulty in this case, we would suggest, because it's quite clear from the documents that the penalty had been decided upon. That's the page 204.
Yeah.
The penalty's been decided upon. The amounts that you have to pay, depending on when you pay it, have been decided upon.
So this
proposed penalties, yeah. and then you're given, and then there is a possibility of raised that they may accept these redress payments being made to the same value.
You
instead.
Point to this letter in relation to the 2016 settlement. There's nothing as black and white as this, is there, in relation to the earlier ones?
I think probably not. The reason I did that was because my learned friend was concentrating on this and said there was no difference between the rest. So I've concentrated on that. I will certainly look overnight and see what precisely the position is in the others. As I understand it, the substance of the situation was the same in relation to the other payments. But,
your submission is at the time there was only one regulatory option, which was a penalty.
Yes.
And therefore one has to judge everything done instead of the penalty in the way that say, which is if it's instead of the penalty, then it has the same characteristics or policy as the penalty. And you say, do you, that if, in this case, with the threat of a penalty coming down the line, SP, called Scottish Power, had thought, well, we better make sure all our customers are properly compensated now, and had done that. And then later on, there's the penalty investigation, and Ofgem concludes that because all that's been done, whereas otherwise they might have imposed a penalty of £23 million, they'll only impose a penalty of £1 now. You would say that is still instead of a penalty and is non-deductible, or not?
If they sorry, I don't think I caught exactly the first part of the financial scenario. Was
all this was done recognising that they had messed up, they'd breached the regulations, and that as a result, Ofgem were beginning to make inquiries about a possible penalty. So before they went any further, they make sure they pay their customers any compensation they can.
Well, when you say compensation, I mean, most of this case is not about compensation, we would submit. Only a very small part of it's about compensation in a true sense. But if they made payments to charities and whatever, and hoped that...
Well, I think £15 million was paid, wasn't it, to customers?
But not
the claims handling section.
Well, we would say not in a conventional kind of compensation. I mean, it was paid, you've seen the document. First of all, it didn't discharge them from any liability for compensation. And it was paid to everyone. It wasn't paid because X had suffered some loss. Indeed, X could now say, I've actually suffered some loss, I want some more. So in my submission, that's not truly compensation in any real sense. But if they decided to pay all their customers £100, hoping that Ofgem would take that into account and then reduce the penalty, then I think that would be, well, that'd be a difficult case because they wouldn't actually be doing it instead of the penalty because they wouldn't know at that stage whether Ofgem would accept it. They would simply be making those payments. I mean, this truly would be voluntarily because they'd be making it voluntarily, hoping that it would have some effect. But the nature of this is totally different. This is something which they're paying knowing because they've agreed it, as my Lord said. It's already been discussed. This letter didn't come out of the blue. It's been discussed.
Well, the reason I asked the question, because there's all possibilities in between as you get closer and closer to a formal agreement. I want to know where the dividing line is.
Yes. Well, what we say is that the policy is that you can't putting it one way, you can't avoid the fact that you're paying a penalty and not deducting it by agreeing to do something else with the regulator. Now that may be done beforehand. In fact, in reality, this was done beforehand. I mean, these things were agreed. We don't know precisely what the negotiations were, but no doubt there were negotiations going on between Scottish Power and the regulator as to the kind of things they might be prepared to do, what they could do, etc., what the regulator would accept instead of the penalty. That's a clear case, we would say. If they just did something hoping it, I think that may be a different case. I'm not saying that if they just woke up one day and said, oh dear, looks like we've breached our regulatory requirements, we better do something quickly to hope we won't get penalised. That might be different. I'm not suggesting that would necessarily be the same.
And going to the narrower, the way you put it, here you've agreed to make these payments instead of a penalty, which by the way would have been a larger penalty. Why does the policy, as described by Lord Hoffman, necessarily apply to those payments?
Well, because from the point of view of the regulator and from the point of view also of the company, the only difference between this and paying the penalty is who they're paying it to. They're paying it for the same reason, we would say, the same underlying reason it's being paid for, which is the breaches that they incurred. They are breaches of the regulations. The only difference is it's not being paid to the consolidated fund, disappearing into the Great Maw, but is being paid to something that I think the regulator probably regarded as more useful, which is it's going to a charity or it's going to customers, or a combination of these things. So to say, well, we get a deduction in a case where we pay it to one person, but we don't get a deduction for the same reason we pay it to the consolidated fund, we would say it doesn't respect the policy.
This may not matter, but are there any rules about where it goes once it's paid to the consolidated fund?
I don't, as far as I understand it, disappears forevermore. Probably goes to pay judges or something.
Not much of it.
No, I think it's just a general, just goes into general tax receipts. Receipts, sorry.
Can we just pursue this a little further? Why does it necessarily follow that recipient makes no difference? I mean, just to take an example, let's say the regulator, let's just assume a working assumption that you are wrong and these sorts of payments are deductible. What would stop a regulator recognising that and saying, frankly, you're going to have to do a bit better on the compensation front? You're going to have to, that number goes up compared to
well, they will have to do that. If that's what's decided, they will have to gross it up, effectively, for tax.
But I'm using the point to just test the policy. I mean, it would be open to a regulator to say, I'm going to gross up, I'm going to reckon on that in fixing the level of compensation, or I'm going to levy a fine equal to the tax benefit. Where's the
Well, I think it's assumed, certainly with fines and penalties, that they are calibrated, not taking account of tax.
No, but you could levy a fine equal to the value of the tax deduction on the compensation. If the regulator understood that one was deductible and one was not, they could reflect that in their decision making.
They could, but you're going very far away from what they're trying to do, which is simply to impose fines to discourage power companies from these activities.
We're already away from the express provisions of the statute, because those express provisions of the statute do not provide for these sorts of voluntary redress payments.
They don't provide expressly, but they do provide in the, well, I think it's thought, and hasn't been challenged, they provide in the words all the circumstances. That's where it provides for it, but not expressly, I agree.
But as you say, in the circumstances, is in all the circumstances. It might take account of compensation payments made years previously, like the 8 million that was referred to this morning, that the regulator might also take into account, and which the revenue may not challenge the deduction for.
Yeah, well, I think it must follow that if it was to be decided that the payments were deductible if they were paid not to the consolidated fund, then in calibrating that, they would have to gross up what they had to pay to take account of the fact that there would be potentially tax. Of course, that causes difficulty because you don't know what the tax profile is going to be necessarily.
So, can I just try and understand, draw a few sort of threads together? But we've been talking a lot about consumer redress orders and where they fit. I mean, they're statutorily a different beast than penalties. So, Section 27A penalties, Section 27G, I think it is, consumer redress orders. They don't always go together. So if the regulator says to a regulated entity, we think you've breached some requirements of your license and you've caused loss and detriment to consumers, we're thinking about making a consumer redress order. And the regulated entity says, get lost, not listening. And the regulator says, here's a consumer redress order. Is that capable of being deducted from the profits for the purpose of tax?
Well, I'm not. I'm certainly not submitting that it's not, in principle, because it could well be an order. It seems to be envisaged that it would be an order to actually compensate for actual loss that particular
Or
have suffered.
to simply say it would cost more than and it'd just be frankly impossible to figure out which individual consumers actually suffered any identifiable loss. They probably wouldn't claim it. Most of them wouldn't know about it. But you must pay for the benefit of all your customers a certain amount,
Which would be a reasonable estimate.
reasonable estimate of the global loss.
But that's not.
I know it's not this case.
No, it's not. I wasn't going to say this case.
I
I was going to say that's not equivalent to a penalty. It's not designed
I
to
get that.
deter.
Well, that was okay. So you're not
It
saying.
doesn't appear as though to me it's designed to deter or.
So you would admit of the possibility that somebody might deduct it.
Yes, because what it's doing is saying it's effectively a kind of ombudsman type scheme. It's saying, rather than going through the courts,
So
you can get your compensation by this method.
and so I think it would necessarily follow if instead of telling the regulator to get lost, the regulated entity had said, "Oh, whoops, terribly sorry. Okay, we'll do it voluntarily. We'll just enter into an agreement with you that you'll take it no further, because we prefer to have the good publicity that will entail, and we'll make it voluntarily." I think your result must follow.
Yes, exactly.
Okay. You say that if the regulator's approach to the regulated entity was, we're thinking about imposing a penalty on you for breach of these regulations, and the regulated entity said, get lost, and the regulator said, we impose a penalty on you, you'd say, clear law, not capable of deduction from profits.
If they impose a penalty, yes.
Yeah.
And
So what we're dealing with here is there are two possibilities. The first is a situation where there is no regulatory option, as I understand it, for the regulator to do anything other than either impose the penalty or reach some sort of agreement instead of imposing the penalty.
yes.
And you say it should be treated as if, or in the same way as if there were a penalty, because it's in lieu of a penalty, irrespective of the nature of the payments within it.
Because the purpose of the amount that's being paid is the same. It's still the agreement which the regulator comes to, and they say this in the guidance, which is actually in this First-tier Tribunal decision, that essentially what they're saying is when we're agreeing these, we don't do a horse trade with the taxpayer. We are still entering into an agreement which has the same, to promote the statutory purpose, which is to deter. So the amount is the same, the 18 million. If they paid a penalty, they pay a penalty of 18 million. If they pay this, they pay 18 million. And that sum, forgetting who it's going to for a moment, that sum is calibrated in order to be a deterrence to the company.
And what statutory weight or purpose can we attach to those statements that you will take us to?
Well,
Are they the equivalent of the legislative purpose that lies behind the actual imposition of a penalty? And if so, how?
what they reveal is that in coming to these agreements, which are of course part of the penalty process, that the regulator is still applying the same approach. So, to what the amount that's being paid is, that it's still a penalty, it's still deterrent, etc. Still has the same deterrent effect that they have to pay 18 million. That's what they're still promoting the same statutory purpose. But you can also see that from the amounts, because the amount is the same.
But to use Lord Hoffman's argument, Lord Hoffman is saying it's clear with a penalty that you shouldn't undermine the effectiveness So you shouldn't dilute the effectiveness of that by allowing the wrongdoer to spread the load amongst taxpayers. And he derives that as a sort of don't undercut the clear legislative purpose behind the imposition of a penalty.
Yeah.
Do you have the same, or what can you show us that indicates that the same legislative purpose lies behind whatever is agreed pursuant to one of these informal arrangements? I mean, has the legislature gone anywhere near this type of arrangement in terms of statement? I mean, do you get it from section 27B in the guidance, or how do you?
Only in relation to guidance that's been issued by the regulator, but that's guidance as to what the regulator's purpose is in entering into these agreements. That's what it tells you. It tells you what the regulator is trying to achieve by doing this. There's nothing in the statute about this. Nothing specifically in the statute about coming to agreements for payments to go somewhere else. I said that. I'm not sure where exactly we were. I think I was looking at the letter. I don't know whether.
Well, we've got.
What point you're wanting?
Well, it rather depends whether you've got a point which you'd like to leave us with for a relatively short few minutes, or whether, in the time-honoured phrase, it's a convenient moment.
I think it probably is.
If you want to leave us with a sort of particular point, then that you can do in a few minutes, then do so.
No, I think I was looking at the letter and I'm going to move on to the notices, etc. So I don't think I can do that.
Right.
And we're certainly well
ahead of time.
Well ahead of time. Yeah.
Good. All right. Okay. Well, thank you very much. So 10:30 tomorrow morning.
All right.